Toughest thing I ever had to argue in court is why my client, who was already in a wheelchair at the time of the accident, deserved over $500,000 settlement.
Insurer tried serving us beyond the time limit and demanded that they attend the next week.
I had to argue that my client fell as a result of somebody else's negligence.
Despite my fact that my client was completely liable and violated the law and made a turn and drove down the wrong way of the street, that he shouldn't be charged and convicted on righteous indignation.
Preventing a catastrophically impaired person from being evicted.
I once had to defend a summary judgment motion brought against my client. It was a big win.
I had to argue the definition of underinsured.
Insurance company was basically trying to shut down their case because they weren't residents of Canada, and we were able to get justice for them for an unfortunate, horrible accident.
I would say every case that goes to court is important, and every case has its own ups and downs and challenges.
The cases that I went to that were most complicated were always impaired driving charges.
You know, I think summary judgment motions have been the hardest thing.
A couple years ago, they wanted to compel the production of records relating to probation matters. They brought a motion on a contested basis. We fought it and we won, and we got costs.
I did a trial over slip and fall and some psychological damages to our client as a result of that.
I just had one with a catastrophic client who had his leg amputated, and the insurance company was denying that it was considered a motor vehicle accident, so we took it to a preliminary hearing and won a few weeks ago.